It's a court ruling with wide-reaching implications for anyone applying for a South African visa from abroad. The High Court has ordered the Department of Home Affairs to stop adding unofficial hurdles to visa applications, like demanding long-term lease agreements which have no basis in law. Now, the ruling follows a case involving the South African High Commission in Cameroon, where an applicant for a critical skills visa was denied the chance to even submit his application. Now, the court has not only ordered the mission to process that application within 10 days, I understand, but has also warned that non-compliance could trigger contempt of court proceedings. It's a strong signal that gatekeeping practices at South African foreign missions must fall in line with the Immigration Act and all ministerial directives. I want to explore this in a little further detail now. I'm in conversation with Aadil Wadee, immigration consultant and the legal representative in this matter. Aadil, a very warm welcome. So, first of all, maybe just an overall sense from you. Is this ruling a one-off, or do you think it's the start of a systemic cleanup at foreign missions as far as visas are concerned?
Thank you, Jeremy, and thanks for having me today on the show. Jeremy, I think as a starting point, the first thing is that it's not a common case for us to take the Department of Home Affairs to the High Court in South Africa for missions abroad. However, in this instance, because of what had happened and because of the position that the applicant had held, he was supposed to be employed as the chief financial officer in South Africa, and because of that, it was decided by the company that we cannot wait any longer in order for us to try and get this application in. So I wouldn't say it's the start of a change whereby the High Court is going to be our new route in order to get applications in. But what it was the fact that in this instance specifically, is that with regards to this applicant, we had to approach the High Court in order to try and get something out of them in order for this applicant to have his application submitted.
And Aadil, in that respect then, how widespread are these unauthorized documentation demands from consulates?
Yes, fantastic question. So I think on that, the first thing is that we have to commend the Department of Home Affairs and Minister Schreiber for what they've done since he's taken office. He has basically come in with fresh ideas. He's come in, he's cleared the visa backlog, he's ensured the continuation of the trusted employee scheme, etc. But what we have seen is that it's taking either a very long time or it's being ignored completely by our missions and embassies abroad, whereby he might implement changes in South Africa, but abroad it doesn't seem to be implemented as quickly as what we thought it would. So it's not just related to the Cameroon itself. It's widespread throughout the world where applications or applicants who are trying to submit outside of South Africa are struggling with requests for documents which are not in any relation to the Immigration Act, its accompanying regulations. It's just basically done by the official on the day. We've seen them change from day-to-day basis where you can submit today and there is no request for something, and then you attend the center tomorrow and there's a completely new request for something which isn't required in terms of the Act.
And why? Why does this kind of practice happen, do you think?
So I don't think it's a communication delay, because we know for a fact that the department does address all these concerns with the embassies abroad. We've seen it insofar as towards the end of last year, the minister issued a directive to embassies abroad to let them know that requesting for additional documents which aren't required in terms of the Act or its accompanying regulations is completely against what they should be doing abroad. The directive was obviously issued only in terms of visitors' visas for 11 ones. It wasn't addressed as a widespread for all visa types, but the fact is that the department is aware that this is happening. They are aware that embassies abroad are making it extremely difficult for applicants to submit, but it comes down to the mere fact that either they are just going against what the department is actually trying to do, which is to make it easier for the mobilization of applicants to South Africa, or it's just something which the embassies abroad and the officials are just reluctant to change the process, which is been the same for them for so many years, and they're scared to implement something such as, for example, a radiological report no longer being needed. They are scared to accept an application and adjudicate it without that because they are so used to what it was like a year or two ago.
The problem, of course, is whether this order is going to lead to meaningful enforcement or simply be ignored again in the future.
Of course. So on that, we definitely take this court order as a landmark decision. It's a decision which can be used and referenced by applicants in the future because of the significance it holds. Obviously, with regards to the fact, as you mentioned previously, is that they were given 10 days in order to accept this application, which shows how the court views this matter, to say that it's not something which we are telling you guys you can have maybe a week, 2 weeks, 3 weeks in order to decide what you want to do. We've given you a set amount of time in order to rectify this, and if you don't rectify it, there will be repercussions. So on that basis, any future application or any future applicant who is trying to submit and is met with these sort of requests or requirements from the officials can definitely reference this order because of its landmark decision, so that they can use it in order to get the applications in.
So let's talk about repercussions then. Do you believe that legal or disciplinary consequences should apply to officials who are essentially acting ultra vires?
Of course, of course. So one of the key things with regards to the order is that if the mission abroad refuses to accept the application within the 10 days, is that we can reapproach the High Court for contempt of court order. And what that essentially basically means is that should the embassy not accept the application, we can request for the minister to be held in contempt, which then means he can be jailed for up to a period of 90 days. Obviously, that is the last resort. It's the last thing we would want out of this whole situation. But with the severity of what they are doing abroad, it is necessary that we have to take extreme legal measures to ensure that these applications are adjudicated in line with both the Act and the regulations.
And just a quick one in conclusion, do you have a sense of how many visa applicants have been unfairly blocked in this way in the past?
I wouldn't be able to give you an exact figure, but what I can tell you is that it's, like I said, it's not just specific to a specific region within, for example, Africa or Europe. It's across the world, and sometimes within specific countries, there is more than one mission whereby one is completely fine. Whereas if you go to the next mission, there is a complete change with regards to what they want to request in order for you to apply. So it is something we're seeing across the world. It's not specific to any region whatsoever, and it's also not specific to, in terms of the missions, it's not everyone. For example, if you go, like I said, on a day, there might be an official who is completely in line with what needs to happen. Yet the next day, there is a different official who does come on the day and request extreme amount of additional documents, which doesn't make any sense as they're not part of the regulatory requirements.
Aadil Wadee, thank you very much indeed.